Hi everyone, welcome to another edition of Tisha's 2-Minute Tips. I'm Tisha Dodge. I'm a lawyer and a business owner, and my mission is to help educate other business owners to make the world a better place. Today we're talking about the $535 million business dating mistake. In this real-life legal case, Enterprise and another company called ETP were builders and operators of oil and gas pipelines. They were interested in doing business together and wanted to know whether converting an existing pipeline would be economically feasible. They entered into an LOI or a letter of intent as well as some other legal documents. Mind you, this was to determine whether the project was feasible or not. This was before they agreed to start building. The letter of intent had some pretty strong language. Neither this letter of intent or joint venture term sheet create any binding or enforceable obligations between the parties, and no binding or enforceable obligations shall exist between the parties with respect to the transaction unless and until the parties have received their respective board approvals and definitive agreements memorialize the terms and conditions of the transactions have been negotiated, executed, and delivered by both parties. Here's what happened. They never consummated the deal, and ETP sued for breach of joint enterprise and breach of fiduciary duty. At trial, despite the strong language of the letter of intent and no formal agreement for the joint venture, the jury found that there was a partnership and a breach of loyalty resulting in a $535 million judgment. In a very, very simplistic explanation, Enterprise thought that they were dating while ETP acted like they were married. I only have a few minutes, so if you want to know more, we'll be diving down into the details of this case and how you can avoid this mistake at Joint Ventures Finding Your Ideal Match. It's happening live this Saturday, February 16th at 1:30. The deadline to sign up is this Friday. Remember, this can happen when your business decides to do business with another. In this case, they didn't form a third business, a third product, or a third service. This mistake can also happen when you form a strategic alliance. Enterprise versus ETP is a complex case that we're going to break it down and make it easy for you to understand. And instead of using all the legalese that makes it boring and confusing, we're going with a love theme. For example, dating is more like a letter of intent, while a marriage is more like a joint venture. In our seminar, we're also going to use terms like don't hate the player, hate the game when we talk about market competition. We created the seminar as the most cost-effective way for you to know what's important before you start negotiating. This seminar gives you the knowledge so that you know how to maximize your side of the deal while minimizing your legal risks. And most importantly, you'll be able to learn how to avoid the $535 million mistake, which was not only costly, but surprisingly easy to make. You'll also save time and lawyers' fees because you'll already know the essential terms that you need to complete your business deal. And you'll have knowledge of cutting-edge laws, which is my gift to you this year. I've talked to other lawyers about this case, and they didn't know about it. This case is still up on appeal, so it is new law. Knowledge is power, and in the business world that moves so fast, having the latest knowledge gives you that business advantage that others don't have. So join us for Joint Ventures Finding Your Ideal Match. Click below to register now. Spaces are limited and we are closing registration this Friday. I hope you found this thought-provoking and helpful. I'll talk to you next time. Thanks.